The courtroom on the fourth floor of the Vancouver Provincial Court building was the kind of room that had been designed to make people feel small. Not in the way that grand cathedrals make people feel small, which is a smallness that lifts you, that reminds you of something larger and more beautiful than yourself. This was a different kind of smallness. The ceilings were high enough that your voice could disappear before it reached the walls. The wooden paneling was dark and dense, the color of old authority. The fluorescent lights overhead cast everything in a pale, flat brightness that made every face look like it was already being examined, already being judged before a single word had been spoken. The gallery benches were hard and unforgiving, bolted to the floor at angles that seemed calculated to make the act of sitting there for more than 30 minutes a mild form of discomfort. Nothing in that room had been designed for the comfort of the people who passed through it. Everything had been designed for the comfort of the institution. Judge Clarence Whitmore had presided over that courtroom for 17 years. He was 58 years old, with grey temples that he had been told, at various points in his career, gave him an air of distinguished authority. He had a broad, well-fed face and the particular kind of smile that develops in men who have spent decades being the person in the room whose opinion matters most. It was not always a cruel smile, but it was always a comfortable one, the smile of a man who has never had a serious reason to question whether his comfort was built on something solid or something borrowed. He wore his robe the way certain men wear uniforms, not as a symbol of the office they serve, but as a confirmation of who they have always believed themselves to be. In the 17 years that Clarence Whitmore had presided over Courtroom 4, he had developed a number of habits that the clerks and junior lawyers who passed through his court had learned to read as carefully as they read the law itself. He had the habit of straightening papers on his bench when he had already made up his mind about something and was waiting for the arguments to catch up to his conclusion. He had the habit of looking at the gallery when a defendant was speaking, as if the faces of strangers were more interesting than the words being said by the person whose fate was being decided. And he had the habit, which was the one that people discussed in hallways and in cafes and in the offices of legal aid clinics, with the particular discomfort of those who witness something wrong but feel powerless to name it directly, of laughing. Not the nervous laughter that any person might produce in a moment of stress or surprise, but a specific, deliberate laugh, deployed at moments when a defendant said something that Whitmore had already decided was beneath the dignity of his courtroom. A laugh that said, without saying it, that the person who had spoken did not belong in the same category as the person who was listening. That Tuesday morning in October, the courtroom was fuller than usual. There were cases from the night before still being processed, bail hearings and arraignments stacked against each other in the tight, impatient way of an overloaded system that had long since stopped pretending it was anything other than overloaded. The public gallery had a dozen people in it, some of them family members of defendants, some of them law students from UBC doing their observation hours, some of them simply people who had stumbled in from the cold outside because the courtroom was warm, and the benches, however hard, were free. Maya was brought in at 9:47 in the morning. She was 23 years old, with dark brown hair pulled back in a simple ponytail. The kind of ponytail you put your hair in when you have more important things to think about than how your hair looks. She was wearing an orange correctional facility jumpsuit over a long-sleeved white thermal shirt, and her wrists were secured in front of her with handcuffs that were slightly too large for her, and which she had learned, in the 4 days she had spent at the remand center, to hold at a specific angle to keep them from sliding down her wrists to her knuckles. She was 5'4", slight, with the kind of stillness about her that people sometimes mistake for passivity, but that is in fact something entirely different. It is the stillness of someone who has learned to observe more than she speaks, because she has discovered that observation is almost always more productive than noise. Her legal aid lawyer was a man named Gerald, who had been practicing criminal defense for 22 years and who had, in that time, developed the particular brand of competence that is indistinguishable from exhaustion to anyone who is not paying very close attention. Gerald was competent. He genuinely believed in what he did. But he also had 14 other files open that week: a sick child at home, a car that needed brakes, and a courtroom in 30 minutes in a different building across town. He had met Maya twice before today. He had read her file carefully, he had taken notes, he had prepared arguments, but he had not had time to learn who she was, because the system that was supposed to provide her with adequate representation had not built time for that into the equation. Maya sat in the defendant's chair and looked straight ahead. She did not look at the gallery. She did not look at Gerald, who was sorting through papers with the practiced efficiency of someone who has done this too many times. She looked at the bench where Judge Clarence Whitmore had not yet appeared, with the steady, unfrightened expression of someone who has already decided how she is going to carry herself through what is about to happen, regardless of what it is. What she had been charged with was this. 3 weeks earlier, Maya had been caught by a security guard at a pharmacy on Hastings Street with 2 packages of children's fever medication concealed in the pocket of her coat. The retail value of both packages combined was $22.40. She had not run. She had not argued. She had stood very still when the guard approached her and had said quietly that she understood. The guard had called the police because the store's policy required it. The police had arrived and processed her because their policy required it. And now she was here, in Courtroom 4, on the 4th floor of the Vancouver Provincial Court building, because the system's policy required that too. What the charge sheet did not mention, what no document in the official file contained, because no one in the chain of events between the pharmacy and the courtroom had asked, was that the fever medication had been for Maya's 4-year-old daughter, who had been running a temperature of 103 degrees Fahrenheit for 2 days in the small apartment on the east side where they lived, the apartment Maya paid for, with the income from 2 part-time jobs that together added up to less than full-time hours and none of the benefits. Her daughter's name was Zofia. She had her mother's dark hair and her mother's stillness, that quality of watchful calm that looked like quietness, but was in fact something that listened to everything. Maya had not had $22.40 that afternoon. She had had $11. She had already bought groceries with her last paycheck, and the fever had started 2 days after the groceries were bought. She had looked at what she had. She had looked at her daughter. She had made the choice that a mother makes when the options available to her have been made impossibly narrow by forces so much larger than a $22 purchase that comparing them is almost an obscenity. Judge Whitmore entered at 9:52. The clerk called the room to order. Everyone stood. Whitmore sat. Everyone sat. The ritual of deference proceeded as it always proceeded, and the room settled into the particular kind of attention that courtrooms produce, a combination of formal alertness and private resignation. Gerald presented the facts of the case in the brisk, efficient manner of a lawyer who respects the court's time. He explained the charge. He noted that his client had no prior criminal record. He mentioned the circumstances of the theft in careful, measured language that was designed to contextualize without appearing to excuse. He used the phrase extenuating circumstances twice and the phrase vulnerable circumstances once. He was doing his job. He was doing it as well as 14 open files and an overloaded schedule would allow. Judge Whitmore listened with the particular quality of attention that Maya had already learned to recognize in the 4 days she had spent watching the world from behind the glass partition of the remand center's visiting room. It was the attention of someone who is waiting for something to confirm what he has already decided, rather than the attention of someone who is genuinely uncertain about what he's going to decide. He straightened the papers on his bench twice during Gerald's presentation. He glanced at the gallery once. When Gerald finished, Whitmore picked up the charge sheet and looked at it with an expression that managed to communicate both boredom and disdain in the same arrangement of features, which is a particular kind of skill. He looked at Maya. She looked back at him without flinching, which seemed to register somewhere in the narrow band of his awareness as something mildly unexpected. "Miss," he said, pausing as if the name on the file were an obstacle he was deciding whether to bother with. "Vasquez." "Yes, Your Honor," said Maya. "You understand what you're charged with?" "Yes, Your Honor." "And you understand," he said in a tone that had begun to acquire the particular texture of a man who is enjoying something, "that regardless of the circumstances, we cannot simply allow people to take what they want from stores because they have decided that they need it." Gerald shifted slightly in his chair. He recognized the tone, too. "I understand the law, Your Honor," said Maya. Whitmore looked at her for a moment, then looked down at the file again. He was reading something, though the way he read it suggested he was looking for something specific, rather than encountering it for the first time. And then he found whatever he had been looking for, or perhaps he manufactured the occasion for what he did next, which is a subtle but important distinction that no one in the courtroom was positioned to make with certainty at that moment. He leaned back slightly in his chair, and then, with the casual ease of someone reaching for a tool they have used many times, he said something in German, not loudly, not with theatrical intent, with the quiet, comfortable confidence of a man who has done this before and found it useful. He said it to no one in particular, or perhaps to the clerk beside him, or perhaps simply to the air of the courtroom, which had always absorbed whatever he chose to release into it, without complaint. What he said, in German, was this: "Was macht eine Person wie diese hier? Sie versteht doch sowieso nichts." Translated into English, what he said was, "What is a person like this doing here? She doesn't understand anything anyway." The clerk kept his eyes on his screen. Two of the law students in the gallery exchanged a glance. Gerald, who did not speak German, frowned at something in his papers that had not changed since the last time he looked at it. The people in the gallery, who had not been law students and who had not studied German, simply heard a sound in a language they did not recognize and processed it as background. The way one processes the ambient noise of an institution one has learned not to fully understand. What no one perceived in that courtroom, in that moment, was the thing that was about to change everything. What no one had thought to ask, what no document in any file had bothered to record, was that Maya Vasquez had grown up in a household where 4 languages were spoken with the regularity of seasons. Her mother was from Colombia. Her father had been born in Frankfurt and raised in Salzburg. She had spent her childhood moving between those worlds and the Canadian world her parents had chosen, collecting languages the way some children collect stones or stamps, not deliberately, not as an achievement to display, but as the natural consequence of living inside different sounds and discovering that each one opened a window onto something the others did not show. By the time Maya was 12, German was as natural to her as breathing. By 15, she had added Italian from a grandmother who refused to speak anything else. By 18, she was fluent in 5 languages and conversational in 2 more, not because she had studied for them in any systematic way, but because she had been paying attention her entire life to the way people use language to say what they mean, and more often to say what they are trying to conceal. She had understood every syllable of what Judge Clarence Whitmore had just said. She stood very still for a moment, the stillness that people mistook for passivity, but it was not passivity. It was the stillness of someone who is deciding very carefully and very precisely what to do with what has just been handed to her, because she has learned that the way you respond to certain moments determines not just what happens next, but what becomes possible afterward. And then she raised her eyes to Judge Whitmore with a steadiness that had nothing defensive in it, nothing afraid, and spoke. "Ich habe alles verstanden, Herr Richter," she said, in German so precise and so unhurried that it filled the courtroom with the quality of something that had been there all along, waiting. "Und ich denke, das sollten alle hier wissen." In English, what she said was, "I understood everything, Your Honor, and I think everyone here should know that." The silence that followed was of a kind that courtrooms rarely produce. Courtrooms produce silence of the formal variety, the silence of procedure, the silence of people waiting for the next step in a sequence they know by rote. What filled courtroom 4 in that moment was a different silence entirely. It was the silence of people who have just understood that what they thought was happening is not what is happening, that the ground beneath a certain set of assumptions has just moved in a way that cannot be moved back. Judge Clarence Whitmore went still. The color in his face changed in the way that faces change when something has penetrated a defense that the person owning the face did not know they were relying upon. It was not a dramatic change. It was the specific, quiet change of exposure, the color that comes up when something private becomes suddenly, irrevocably public. The clerk looked up from his screen for the first time in the hearing. Gerald set his papers down. One of the law students in the gallery opened his notebook to a fresh page. But Maya was not finished. She continued, shifting into French with the same unhurried calm, addressing not only the judge but the entire courtroom, because she had understood, in the moment she decided to speak, that this was not a private conversation and had never been one. Pour que tout le monde comprenne clairement ce qui vient de se passer ici. Je voudrais expliquer ce que le juge a dit dans une langue qu'il pensait que je ne comprenais pas, in English, so that everyone here understands clearly what just happened. I would like to explain what the judge said in a language he believed I could not understand. She looked at the gallery, at the faces that had gone from the polite, distanced attention of people observing a procedure to something sharper and more present, at the law students whose pens were now moving, at the family members of other defendants who had straightened on the hard wooden benches, at the people who had come in from the cold and who were now sitting very upright, with the expression of people who have accidentally walked into something important and know it. And then she said it in English, plain and direct, the way a person states a fact that requires no embellishment because the fact itself is sufficient. Judge Whitmore said in German, and I am translating directly, "What is a person like this doing here? She doesn't understand anything anyway." The sound that moved through the gallery was not a sound that courtrooms are designed to produce. It was the sound of people being reminded that the institution they are sitting inside is made of choices, and that choices can be examined. And that examination requires first that someone decides to look. Gerald was on his feet before the sound had fully settled. He was asking for an immediate recess. His voice had a quality it had not had before, not the competent efficiency of a man with 14 files, but the particular alertness of a lawyer who has just been handed something that changes the shape of what he is doing. Judge Whitmore's gavel came down once. The sound of it was harder than usual, or perhaps it only seemed that way because the room had become so much more attentive to the quality of every sound being made within it. "We will take a 15-minute recess," he said. His voice had changed too. Something had left it. The comfortable ease that had characterized every sentence he had spoken in that courtroom for 17 years was not entirely gone. But it was no longer complete. There was something in it now that had not been there before. The audible texture of a man who has realized, too late to undo it, that the assumption he had been operating on was wrong, that the language he had chosen as cover was not cover, that the woman standing before him in handcuffs and an orange jumpsuit had heard every word. He stood. The clerk called the room to order, Everyone rose, but this time, as Whitmore walked toward the door behind the bench, he did not look at the gallery, and he did not look at Maya, because some things, once seen clearly, are difficult to face without the armor of the assumption that was just removed. And that armor, for Judge Clarence Whitmore, on that Tuesday morning in October in Courtroom 4 was gone. What no one in that courtroom could have known yet, and what Maya could feel only as an intuition, pressing against her ribs from the inside, was that the 15-minute recess was not going to fix what had just broken open in that room. Some recesses end, and the proceeding continues, as if the pause had never happened. Other recesses are the point after which everything is different. The two look identical from the outside, in the moment before you know which one you are inside of. This was the second kind. Maya sat back down in the defendant's chair and placed her cuffed hands in her lap. She looked at the empty bench where Whitmore had been sitting. She breathed. She thought about Sophia, about the fever that had broken on the third day, about the small apartment with the worn carpet and the window that looked out over the alley where someone had planted a single pot of marigolds on the fire escape across the way, impractically and stubbornly orange against the grey of the building. She thought about the choice she had made 3 weeks ago in the pharmacy, the calculation that had fit on the back of a single moment, the weight of a child and the weight of a price tag, and the weight of what was available to a person when the world has arranged things so that the available options are all insufficient. She thought about the language her father had taught her by sitting at the kitchen table in the apartment in East Vancouver and reading aloud from the same paperback novels he had been reading since before she was born. His voice finding the German syllables with a warmth that had made the language feel like something that belonged to her before she had ever decided to claim it. And she understood, sitting in that hard wooden chair with the fluorescent light overhead and the gallery behind her slowly filling back in with people who were whispering to each other in a way that courtrooms almost never permit, that what had happened in the past 17 minutes was not an ending. It was a beginning of a different kind, the beginning of something that could not be put back into the shape it had been in before the first German word had left Whitmore's mouth in the comfortable certainty of not being understood. What she did not yet know was how large that beginning was. She would learn. In the weeks and months that followed that Tuesday morning, she would learn exactly how large it was and what it meant, and what it required of her, and what it ultimately made possible. For herself, for Sophia, and for every person who had ever stood in handcuffs in Courtroom 4 and heard something said in a language that was meant to be a wall and had no way to say so. But that learning was still ahead of her. For now, there was only the chair and the light and the sound of people returning to their seats, and the knowledge, quiet and solid as anything she had ever known, that she had told the truth in a room that had expected her silence, and that it had been heard. The 15-minute recess stretched to 40. No one who had been in the gallery left. This was unusual. Recesses in provincial courts are typically moments when people scatter, check their phones, find water fountains, step outside into the grey October air for a breath of something that is not recycled institution. But no one left Courtroom 4 that morning, because every person in the gallery had understood, with the instinct that people develop for moments of consequence, that leaving would mean missing something that would not repeat itself. Gerald had gone behind the doors that led to the consultation area, and when he came back, his expression had the particular brightness of a lawyer who has just spoken to his client and discovered that his client is not who he thought she was. He sat down next to Maya and leaned in with the focus of a man who has abruptly rearranged his priorities. "Why didn't you tell me?" he said. Not with accusation, with the genuine bewilderment of someone who has been working with incomplete information and has just realized how incomplete. "You didn't ask," said Maya. It was not a reproach. It was simply the truth, stated with the evenness of someone who has spent a long time accepting the fact that the world operates on assumptions that frequently leave her out. Gerald was quiet for a moment. He looked at his notes. He looked at Maya. He said, "How many languages?" "7," she said. "8 if you count Latin, which my father argued counts on principle, even if nobody speaks it anymore." Gerald wrote something in his notes. Then he wrote something else. Then he looked up with an expression that had shifted into something more resolute. The expression of a lawyer who has just understood that the case in front of him is not the case he thought it was. "I need you to tell me everything," he said. "From the beginning, all of it." Maya told him. She had 40 minutes, and she used them precisely, without embellishment and without omission, the way she had learned to tell stories that matter, which is to say, with the understanding that every detail either earns its place or it doesn't, and that the details that earn their place are the ones that are true. She told him about her mother, Elena, who had come to Vancouver from Bogotá in 1992 with 2 suitcases and a degree in literature that the province of British Columbia had not recognized and never would, and who had spent the next 3 decades working as a home care aide with the particular grace of someone who has found that the work of caring for people is worth doing, even when the world undervalues it to the point of insult. She told him about her father, Thomas, who had come from Frankfurt by way of Salzburg and a failed academic career in comparative linguistics. A failure he had never been bitter about because it had led him to a kitchen table in East Vancouver, where he could read paperback novels aloud to his daughter and call it education. She told him about growing up between those worlds, about the way language had been in their household, something you moved through rather than something you studied. The way you move through weather, about the kitchen where German and Spanish and English and French shifted into and out of each other with the casual ease of people who have long since stopped noticing that they are switching, because the switch is not a performance, it is simply the texture of how thought happens. She told him about school, where she had been the kind of student that certain teachers love unreservedly and others find quietly threatening, the kind who asks questions that go slightly past the end of what the lesson is designed to cover. About university, 1 year of it, at Simon Fraser, studying linguistics before the money had run out in the particular way that money runs out, for people who do not have the kind of family that can fill the gap between what student loans cover and what a year of university actually costs. She told him about the 2 part-time jobs, the morning shift at a bakery in Strathcona and the evening shifts at a grocery store on Commercial Drive, and about the 8-hour gap between them in which she picked up Zofia from the woman down the hall, who watched her for $40 a day, which was less than a licensed daycare would cost, and more than Maya could consistently afford, and about the arithmetic that governed her life, the precise and unforgiving arithmetic of someone who has learned to calculate to the last cent, not as a skill, but as a survival requirement. And she told him about the afternoon of the pharmacy, about Zofia's fever, about the $11, about the moment of decision in the aisle between the cold remedies and the vitamins, where she had stood with both packages in her hands and done the calculation that produced only one available answer. Gerald listened to all of it without interrupting. When she finished, he sat for a moment with his pen resting on the notepad, not writing, simply thinking with the quality of attention of someone who has been practicing law long enough to know the difference between a case and a person, and who has just been shown, clearly and without ambiguity, that he was dealing with a person. "There are things here," he said, "that should have been in your file from the beginning." "I know," said Maya. "I'm going to ask for an adjournment. I need time to bring forward some of this context properly. The circumstances of the theft, Zofia, the financial situation, this needs to be presented differently." "All right," said Maya. "And the other thing," Gerald said. He paused. "What Whitmore said in German, that's going to go somewhere." Maya looked at him. "I know," she said again. What she meant, and what Gerald understood she meant, was not simply that a complaint would be filed, or that an article might be written, or that a committee might be convened. What she meant was that what had happened in the first 17 minutes of that hearing had become, in the moment she chose to translate it aloud, a matter of record. It had been heard by law students who would write about it in their observation journals and discuss it in their seminars. It had been heard by people in the gallery who had phones, and who had, in 2 cases that Maya had not directly observed but which would become apparent in the following 24 hours, been recording the audio of the proceedings from the moment she began to respond in German, as members of the public are legally permitted to do in Canadian courtrooms. The thing that Judge Clarence Whitmore had believed was private had not been private. It had never been private. It had simply been protected by an assumption. And assumptions, Maya had learned in 23 years of moving between languages and worlds and the spaces between them, are the most fragile form of protection that exists, because they require the cooperation of the person they are protecting against, and she had never agreed to cooperate with that one. When court reconvened, Judge Whitmore looked different than he had looked before the recess. Not dramatically different, not broken or diminished in any way that a stranger walking in would have noticed. But to the people who had been there before the recess and were there after it, there was something changed in his bearing, in the particular quality of the ease with which he normally occupied that bench. The ease was still there, but it was no longer entirely natural. It was being maintained, which is not the same thing. Gerald requested the adjournment. He cited incomplete documentation of the defendant's circumstances and the need to present proper context for the court's consideration. His voice had the calibrated firmness of a lawyer who is asking for something he knows he has the right to ask for and who intends to be very clear about that. Whitmore granted it. He did so without the elaborate commentary that he sometimes attached to procedural decisions, the kind of commentary that communicated, without technically saying so, that granting the request was an act of generosity rather than an obligation. He simply said the date of the next hearing and banged his gavel, and that was that. Maya was processed back through the system that afternoon. She made the phone call she was allowed to make, and the woman down the hall, whose name was Diane, and who had been watching Zofia for the past 4 days, with a matter-of-fact competence that Maya had been grateful for every hour of those 4 days, answered on the second ring and said that Zofia was fine, that the fever was completely gone, that she had eaten 2 bowls of cereal for breakfast and was currently watching cartoons, and had asked about her mother approximately 14 times since waking up. Maya said thank you in the way that you say thank you when the word is not adequate but is all that is available and must somehow carry the weight of everything that is not being said. That evening, in the remand center, she sat on the edge of her bunk and thought. Not anxiously, not with the churning quality of worry that the circumstances might reasonably have produced, with the clear, deliberate quality of thought that is not the absence of feeling but is feeling organized by purpose. She thought about what Gerald had said about things going somewhere. She thought about the law students with their notebooks. She thought about the 2 people she had not seen, but who had, as she would later learn, been quietly recording. She thought about the 17 years that Courtroom 4 had been Whitmore's room, and about all the people who had stood where she had stood, in handcuffs they held at a specific angle to keep from sliding, and about how many of those people had heard things they could not respond to because the language used to say those things had been chosen precisely to ensure that they could not. She thought about her father's voice reading German paperback novels at the kitchen table, about the way certain words in German have no equivalent in English, the way a language carries inside it the specific texture of the world that made it. About the word Schadenfreude, which is the pleasure taken in another's misfortune, and about the particular irony of the fact that the language chosen to deliver a humiliation had also, in the same gesture, delivered the means by which the humiliation would be undone. She thought about Zofia, asleep somewhere on the other side of the city in Diane's apartment, with the fever gone and the cartoons watched and the cereal eaten. About the way Zofia had already, at 4 years old, begun to pick up the Spanish that Elena spoke on the phone every Sunday with the family in Bogotá. The way a child picks up language when it is present in the air around her, naturally and without effort, because children understand instinctively what adults sometimes forget, which is that a language is not a barrier or a credential, it is a door, and every door you learn to open makes the next one easier. She did not sleep well that night, but she slept, and when she woke before the lights came on in the corridor, she lay on her bunk and counted her languages the way other people might count their blessings, not as an inventory of achievement, but as a reminder of what was there. German, Spanish, English, French, Italian, Portuguese, Mandarin, which she could speak but not write with any fluency, a gap she had been meaning to address for 2 years and which had consistently been pushed back by the more immediate demands of the arithmetic of her daily life. 7 languages, 8 if you counted Latin, which her father had argued, and which she had never stopped believing, counts on principle. She thought, I have always had more than they believed I had. I have always been more than the space they assigned me to. And she thought, that is true of everyone who has ever stood in this room. She carried that thought with her into the morning. The adjournment lasted 3 weeks. In those 3 weeks, things happened that Judge Clarence Whitmore had not anticipated, because his operating model for the past 17 years had not required him to anticipate the consequences of what he said in German in his own courtroom. And models that go unchallenged long enough begin to feel like laws of nature rather than choices. They are not laws of nature, they are choices. And choices, unlike laws of nature, can be reversed, exposed, and made to answer for themselves. The recordings surfaced on the 2nd day. One of them had been posted to a community legal advocacy account on social media with a brief, careful caption that said only, "This is from a courtroom in Vancouver. Listen to what is said at the 1 minute 42 mark, and then listen to the response." The caption did not editorialize. It did not use words like disgraceful or shocking or outrageous. It let the audio carry what it carried, which was more than any editorial language could have added. By the end of the 2nd day, the recording had been shared several thousand times. By the end of the 3rd day, it had been picked up by 2 major Canadian news outlets and 1 international wire service. The Canadian Judicial Council had received 17 formal written complaints. The British Columbia Civil Liberties Association had issued a statement. Gerald had been contacted by 2 senior lawyers who offered to join the defense team on a pro bono basis. One of them, a former Crown prosecutor with considerable experience in judicial conduct proceedings and a reputation for the kind of patient, methodical thoroughness that is useful when you are building a case that needs to be airtight. Maya heard about most of this second-hand, through Gerald and through the fragments of information that make their way through the walls of remand centers, the way sound makes its way through walls, muffled but present, carrying the general shape of what is happening even when the details are blurred. She received a letter from Gerald on the 5th day that was 3 pages long and carefully organized, which told her as much about his state of mind as its contents did. Gerald was not a man who wrote 3-page letters without reason. He told her that the bail hearing was being expedited, that 2 things had happened which changed the calculation significantly. The first was the recordings, and what they had made visible to the public and to the institutions that govern judicial conduct. The second was something that the expanded legal team had found when they began to properly document her circumstances, something that should have been in the original file, but had fallen through the gaps of a system that processes people too quickly to consistently notice the full shape of who they are. There was a support program through BC Housing that Maya had been eligible for, and that would have covered the gap between her income and a stable living situation in a way that might have made the pharmacy a non-event. A situation that never needed to occur. She had not known about it, not because the information was hidden, but because navigating the matrix of available support programs in the province of British Columbia requires a kind of knowledge that is not evenly distributed, that clusters in certain communities and certain professions and certain social networks, and is simply absent in others. Maya had not had access to that knowledge. No one in her life had thought to ask whether she did. Gerald's letter said, in the careful language of a lawyer who has learned to be precise about these things, "The circumstances of this case reflect a systemic failure of information access that is not unique to your situation, and which the expanded team believes should be part of the public record of these proceedings." Maya read the letter twice. She folded it carefully along its original creases and put it under the thin mattress of her bunk, where it would stay until she needed to refer to it again. She thought about the phrase, systemic failure of information access. It was an accurate phrase. It was also, she knew, a phrase that had been carefully chosen to communicate something real while remaining navigable within legal proceedings. The real thing it was communicating, the thing beneath the careful language, was something she had known for her entire conscious life and had no particular name for, because the people who name things are not generally the people who experience them most directly. It was the thing that happens when a system is designed to serve people who already know how to operate within it, and is then made available, theoretically, to people who do not, without providing the knowledge that would make the availability real rather than nominal. It is the gap between a door being unlocked and a door being opened. And it is, Maya had come to understand, one of the most effective mechanisms of exclusion that exists, precisely because it is invisible to the people who never encounter it, and therefore requires no one to actively maintain it. It maintains itself. The bail hearing was expedited to the following Thursday. It lasted 22 minutes. Maya was released on her own recognizance, with conditions that Gerald described afterward as entirely standard. She walked out of the remand centre into an October afternoon that was exactly as grey and cold as the October afternoon she had walked into it, and she stood on the sidewalk for a moment, breathing, before Diane's car pulled up with Zofia in the back seat, who was wearing a yellow rain jacket and who threw herself at her mother with the force of 4 years old and 48 hours of television and Diane's cooking and the particular desperate love of a small person who has been separated from the person she needs most. Maya held her daughter on the sidewalk with both arms and did not say anything for a long moment. She did not need to. Some things do not require language. Some things are communicated entirely and completely without it. Diane, who was 61 and had been a practical and unsentimental person her entire adult life, and was not about to change that now, waited until the moment had passed its most intense point and then said, "There's soup at the apartment. Lentil. Don't argue with me about it." Maya did not argue. In the weeks that followed her release, 3 things happened in parallel, each of them proceeding at its own pace and by its own logic, intersecting at points that were sometimes visible and sometimes not. The first was the judicial conduct proceedings. The Canadian Judicial Council's process for investigating complaints against federally appointed judges is slow and formal and designed with the particular care of an institution that understands itself to be making decisions that carry weight. But Whitmore was a provincially appointed judge, which meant the process ran through the British Columbia Judicial Council, and it ran with the compressed urgency of a body that had received 17 formal complaints, national media coverage, and recordings of an incident that was, as one of the reviewing members described it in a memo that was later made public, not ambiguous in its nature or in its implications. The investigation was opened within 10 days of the original incident. Gerald was notified. The expanded legal team prepared documentation. 2 of the law students who had been in the gallery that morning submitted written accounts of what they had witnessed. The 2 individuals whose recordings had been posted online cooperated fully with the review process and provided unedited copies of their recordings. A retired provincial court judge who had been appointed to conduct the initial review completed his preliminary report in just over 3 weeks, which is fast by the standards of these processes, because some things, when examined carefully and honestly, do not take a long time to see clearly. The second thing that happened in parallel was Maya's case itself. With the expanded legal team, with the properly documented circumstances, with the context that should have been part of the record from the beginning, the case looked different. Not different in terms of what Maya had done, because what she had done was not in question. She had taken the medication. She had not lied about that, and had no intention of beginning. But different in terms of what the act meant, in terms of what had produced it, in terms of what the appropriate response of a justice system was to a situation produced by the intersection of poverty and inadequate support access and a sick child and the specific arithmetic of a life lived at the margin of what is sustainable. The Crown's position shifted. This is not unusual when circumstances are properly presented. Crown prosecutors in Canada have significant discretionary power in how they approach cases, and the ones who use that discretion well understand that the purpose of the justice system is not to produce the maximum number of convictions, but to produce just outcomes. The prosecutor assigned to Maya's case had been practicing for 11 years. She had children of her own. She had read the file carefully, all of it, including the parts that had been added since Gerald's team had expanded the record. She and Gerald had a conversation that Gerald described afterward to Maya as productive. Maya did not ask him to be more specific than that, because she had learned that productive, in the language of legal proceedings, means something specific and useful, and that pressing for more detail before the appropriate time does more harm than good. The third thing was the thing that had not been planned, and which Maya herself had not anticipated when she had stood in the courtroom and translated Whitmore's German aloud. It was the thing that tends to happen when a specific act of speech in a public forum touches something that many people have been carrying privately and have had no framework for naming. People began to write to her. Not to her directly at first, because she was not yet public in the way that allows people to find a direct address. They wrote to the legal advocacy organization that had posted the recording. They wrote to the news outlets that had covered the story. They wrote to Gerald, whose name had appeared in the coverage, and who had developed the practice of reading the letters at the end of each day and setting aside the ones that Maya should see. The letters were from people who had been in courtrooms, who had been in hospitals, who had been in schools, in employment offices, in housing authority waiting rooms, who had been in the spaces where institutions intersect with individual lives and where the gap between the theoretical availability of something and its practical accessibility can determine the entire shape of what a person's life becomes. People who had heard things said or implied or communicated without words, in moments when the person doing the communicating believed they were not being fully understood. People for whom Maya's translation of those 12 German words in Courtroom 4 had functioned as a kind of permission, a demonstration that the act of naming what you have witnessed is possible and survivable and sometimes the beginning of something larger than itself. Gerald brought her a selection of these letters on a Tuesday afternoon, 3 weeks after her release, when she came to his office for a case update meeting. He had not planned to bring them, but he had read them over the weekend, and something about them had seemed to him important enough to share. Maya read them at the small table in the corner of Gerald's office while he made coffee. She read slowly, the way she read everything that mattered, with the full attention that slow reading requires, and that the pace of her daily life had not always allowed, but that she made room for when the reading was important enough. When she finished, she sat for a moment with the letters in her hands. "How many are there?" she asked. "In total, about 240, Gerald said from the small kitchen area behind her. "I only brought a selection." Maya was quiet. Gerald brought the coffee and sat across the table and let the quiet be what it needed to be. "I didn't know it would do this," she said finally. Not with surprise, exactly, with the particular kind of awareness that comes from understanding the full weight of something that you began with a much more limited sense of. "It doesn't always," Gerald said. "Sometimes things like this happen in public, and they're heard once and then they're not heard again. But sometimes they land somewhere that was already prepared to receive them, because enough people had the same experience and no language for it yet." Maya thought about that, about language, and about the specific function it serves when it gives form to something that existed before the words, but that the words make possible to see and hold and pass on to others. Her father had told her once, sitting at the kitchen table with a German paperback, that one of the things he loved about being a person who lived inside more than one language was that you were always being given new ways to see the same thing. That each language was not just a different code for the same ideas, but a different set of lenses, and that wearing different lenses changes not just how you see, but what you are able to see. Some things are only visible through certain lenses. Some truths are only speakable in certain languages. And some silences are only breakable when you happen to possess the specific language that was chosen to enforce them. She thought about Whitmore choosing German, about the particular confidence of that choice, about the assumption embedded in it, which was that a woman in an orange jumpsuit in a remand facility facing a theft charge for $22.40 did not have access to the language he had chosen to diminish her in. It was an assumption built on another assumption built on another, a structure of assumptions that had never been examined because it had never needed to be. Because no one who had stood in that position in that courtroom before had been able to dismantle it from the inside until she had. Not because she was exceptional, not because she had been given anything that others had not deserved, but because she happened to have been raised at a kitchen table in East Vancouver by a man who read paperback novels aloud in German and believed with the consistency of someone who has chosen a principle and decided to live by it, that language is a form of belonging, and that belonging to more than one language means belonging to more than one world, and that this is one of the most specific and useful things a person can be given. She had been given it. And in the moment Whitmore had opened a door he believed was locked. She had walked through it. The Judicial Conduct Review concluded 41 days after the original hearing. The report was thorough, 11 pages, detailed and specific in its identification of what had occurred and what it meant. It found that Judge Whitmore's use of German to make a derogatory comment about a defendant who was present in his courtroom constituted a serious breach of judicial ethics, specifically in the areas of impartiality, respect for the dignity of participants in court proceedings, and the fundamental obligation of a judge to ensure that every person who appears before the court is treated with the respect owed to them by their status as a person, not by their presumed social position or their presumed linguistic access. The report recommended a formal reprimand. It recommended that Judge Whitmore complete a mandatory program in unconscious bias and cultural competency in the judicial context. It recommended that he not be assigned to cases involving defendants from cultural or linguistic minority backgrounds for a period of 6 months pending the completion of that program. And it recommended that the court system examine its protocols for documenting and assessing the full range of circumstances affecting defendants in cases involving low-value property offences, with specific reference to the role of systemic poverty and inadequate support program access in producing outcomes that the justice system is then required to process. The last recommendation was the one that took the longest to move. Recommendations about examining protocols always take longer than recommendations about individuals, because individuals have names and specific actions and clear timelines, while protocols are structural and slow and resistant to the kind of clear narrative that produces rapid change. But it moved, slowly as these things move, but in the direction of something real. Maya's case resolved on the same day the Judicial Conduct Report was made public, which was not planned, and which Gerald described as an interesting coincidence, and which Maya said she preferred to think of as the kind of timing that happens when the facts in a situation are aligned in the same direction. The Crown withdrew the charge, not because what Maya had done had been undone. It had not been undone. It had happened. But because a system that understood its own purpose had examined the full picture of what had produced that act, and had concluded that what was needed here was not a conviction, but a referral to the BC Housing Support Program, for which Maya had always been eligible, to a caseworker who would spend 3 appointments mapping the exact shape of her circumstances and identifying, with a specificity that required time and attention, what was needed to make the available support actually available, to a community legal organization that ran a workshop on navigating social support programs, twice a month, in a church basement 4 blocks from Maya's apartment. Maya attended the first workshop on a Thursday evening. She brought Zofia, who sat under the table drawing on the back of a handout about tenants' rights, and fell asleep on Maya's jacket just before the end of the session. The workshop was led by a woman named Patricia, who had been running it for 9 years and who answered questions with the patient authority of someone who has explained the same things many times and has not grown tired of explaining them because she remembers what it was like not to know them. Afterward, when most people had filed out and Patricia was stacking chairs, Maya helped without being asked, the way she helped with things, automatically and without commentary. Patricia looked at her. "You're the one from the courtroom," she said. "Yes," said Maya. Patricia nodded. "My daughter sent me the recording," she said. "She said, 'Mom, you have to watch this,' and I watched it." She stacked another chair. "I've been running this workshop for 9 years. Do you know how many people come through here who needed it 3 years before they knew it existed?" "A lot," said Maya. "All of them," said Patricia. "Every single one." Maya picked up Zofia and carried her home through the October evening. Her daughter's weight against her shoulder, the marigolds on the fire, escape across the alley gone now because October had come for them. But the pot still there, orange plastic against grey concrete, stubborn in its staying even when the flowers had left. She thought about the letters that had been written to her, about the 240 people who had been in rooms where something was said or implied or communicated in the confident assumption that they could not fully receive it. About the particular cruelty of that specific assumption, which is the cruelty of erasure, the cruelty that says you are not present enough to be worth guarding against. And about the particular power of the specific refusal she had offered, which is the refusal that says, "I am here. I have been here. I have heard everything, and I will not pretend that I have not." She put Zofia to bed. The child's face in sleep was as still and watchful as it was when she was awake. That quality of attention that Maya had recognized as her own and that she understood now was not something Zofia had inherited from her, but something they had both arrived at independently through different versions of the same necessity. The necessity of paying close attention to a world that frequently prefers not to be paid close attention to. Maya sat at the kitchen table after Zofia was asleep. She had a second caderno, the word her grandmother had used, a notebook open in front of her, and a pen. She was writing, not for Gerald, and not for any proceeding, and not for the 240 people who had written to her. She was writing for herself, in the way she had always written in her notebooks, moving between languages as the thought required, finding the word in whatever tongue had the best lens for that particular thing, building sentences that belonged to no single language but to the space between all of them. She wrote about her father's kitchen table, about the paperback novels, about the way German sounds when it is read aloud by someone who loves it, which is different from the way it sounds when it is used as a weapon, the way all things used as weapons sound different from the way they sound in the hands of people who love them. She wrote about Zofia, about the particular quality of being responsible for a person who is learning the world from scratch, who has not yet decided which things to be afraid of and which things to trust, who is building her understanding of what is possible from the material of what she observes, what her mother specifically does in the moments that matter. She thought about what Zofia would remember when she was old enough to remember things, what image she would carry of her mother in the year she was 4 years old and had a fever of 103 degrees, and her mother was taken away in handcuffs and came back 3 weeks later and carried her home through the October evening and held her in both arms on the sidewalk without saying anything. She thought, she will remember that her mother did not look away. That was what she wrote in the end, in English, at the bottom of the page in her notebook, under sentences in Spanish and German and French that had been working their way toward it from different directions. She will remember that her mother did not look away. That when someone said something in a language meant to erase her, she translated it into the language of everyone present. That she stood in a room designed to make her small, and was not made small. Not because she was extraordinary, because she was there and paying attention and willing to say what she had heard. Some people, when they stand in rooms like that, have no language for what they witness. The rooms depend on this. The rooms are designed around this. The particular architecture of erasure requires the silence of the erased. Maya had the languages, all 7 of them, 8 if you count Latin, which her father argued counts on principle. She had used them, and in the doing of it in that 22-minute window in a courtroom in Vancouver on a grey October morning, she had done something that one person rarely manages to do entirely alone, but which one person, in the right moment with the right tools, can begin. She had made the room slightly different from what it was before she entered it. Stories like Maya's happen more often than the world decides to notice. They happen in courtrooms and in hospitals and in the offices of institutions that manage the lives of people they have not been designed to fully see. They happen every time someone in a position of power chooses a private language to say what they would not say in public. And every time that choice rests on an assumption about who is and is not present enough to understand. What rarely happens, and what makes Maya's story worth telling, is not that she was humiliated. She was. What makes it worth telling is what she chose to do with the moment. She chose to translate, to speak in the language of the room, and the language before that, and the language before that, to make visible what had been made invisible, to refuse the role of person who does not understand, not with anger and not with performance, but with the steady, unhurried clarity of someone who has always understood and has simply, finally, been given the precise occasion to say so. If this story reached something in you, share it, not because the world owes Maya Vasquez a viral moment, but because somewhere right now there is a person standing in a room where something is being said in a language they are not supposed to understand, carrying more than the room can see, waiting for evidence that it is possible to speak. These stories need to travel. Subscribe for more stories the world prefers to leave untold.